We'll hear the first case, Christiansen.
Good morning, Your Honors. May it please the Court, my name is Susan Chana Lask for Matthew Christiansen, the appellant. Today I'm here to reconcile Simonton from 2000. When I look at the cases, Your Honors, obviously Simonton was in 2000 and it was based on a test of literally sexual activity, and it appears to me that, well, the case is clear to me, that it actually carved out a group of people based on their sexual activity that do not get protection under Title VII. But Title VII, the spirit of it, is about skills, not who you sleep with, not who you love. I can't reconcile, and I don't think the circuit court can do the same, to reconcile Simonton with Lawrence versus Texas in 2003, 3 years later, that said, wait a minute, we can't put people in jail because of who they're sleeping with, sexual activity.
And can you prevail if Simonton is not overturned?
No, Your Honor.
So you're calling for the court to overturn Simonton, which can only be done through an in-bank proceeding.
Yes, Your Honor. Simonton has to be overturned. It has to be vacated. It doesn't make sense considering even the EEOC's Baldwin case, which gives us plenty of information, and I'll let the EEOC handle that in her argument. It doesn't reconcile with the latest district courts of Boutillier in this circuit.
I'm sorry.
But below, I took you to be making both a sexual orientation claim and a sexual stereotyping claim. So you are now abandoning the sexual stereotyping claim? Because I read the district court to have said that that wasn't adequately pled.
The district court did say it was not adequately pled. I don't want to abandon the sexual stereotyping claim at all. No, I don't. I would definitely focus on the sexual orientation claim here today because of Simonton. I need to get past that, and I think the circuit has to as well.
There are a variety, as you know, of different theories. One says that discrimination on the basis of sexual orientation treats employees less favorably because of their sex and is thus discrimination. A second says that discrimination on the basis of sexual orientation treats employees less favorably based on sex of their associates, associational relationships, and thus is sexual discrimination. Then there's a third that says this is discrimination on the basis of stereotypes. Is there one of these, two of these, all of these that you embrace? Is there one in particular that now as you stand before us that you embrace?
I would like to give the court a test, a but-for test that I think embraces 1 and 2, which would be, and like Boutillier, and I apologize if I mispronounce it, says the problem here is the target is the sex. So the test would be but for the sex of the employee, and we'll take number 2, and the sex of who he associates with, that they are being discriminated in this manner, which again my position is violates the spirit of Title VII because it's not about sex per se, the sexual activity, it's about skills. So it doesn't matter who you slept with last night as long as your skills are good, because when we go in, well, I'll stick with the question. It's a but for the sex of the employee and but for the person he associates with. And it's the same as, Your Honors, in Holcomb, where this court resolved racial discrimination. Interracial couples get protection. Why not intrasexual couples get protection?
So your position is with the EEOC that sexual orientation discrimination is of necessity sex discrimination, or because of sex for the purposes of Title VII. Am I understanding the argument? that in all cases of sexual orientation discrimination, that discrimination is of necessity discrimination because of sex.
Because of sex. It's the first thing that is targeted. You know, I just raised my hand as an illustration. The left hand here is our employee. He is not heterosexual, and that's why I'm here today. It's to protect the people that happen to not be heterosexual, because Simonton only protects people that are heterosexual. So here's our employee who's not heterosexual. Here's our employer, harasser, whatever we want to call them, and he's saying a male. That's the first thing you see. And then we'll bounce back to here, and his mind starts calculating, saying that male should be with women, but because he has a picture of his husband on the desk, I want him out. I'm going to harass him. I'm going to do what Simonton warned us in the beginning of its case. Be careful, because we're going to tell you facts, and we're not even going to tell you all the facts. Something so reprehensible, you're not going to like what you read. And then we read about the pictures and the lewdness and what Mr. Simonton went through that led him to a heart attack even. Your Honors, when I read the 110th congressional record, it was all about skill. Nobody was talking about sex or who you love. It's all about skill. And it also said, and I'll get back to Simonton and his heart attack and the reprehensible facts that this court warned us. Wait till you read this. They also say on that floor in the 110th record, nobody should be afraid for their life when they go to work. Simonton almost died. Many people probably, who knows who's committing suicide? Well, maybe they are, all these people jumping off the George Washington Bridge because they can't keep their jobs.
The congressional record with respect to sex is not very extensive at the time of the passage of that law. Indeed, as you know, it was proposed with respect to sex as a way of defeating the whole measure, and it didn't happen. The measure passed, but the legislative history is quite sparse, which may in part explain why for a very long time, rightly or wrongly, circuit courts and the EEOC were of the view that sexual orientation was not covered. Just trying to understand how we got to where we are, which is not to say that decides what we decide right now.
Your Honor, with all due respect, let me correct you. First of all, there's a lot of fallacies. The first thing I did when I got this case, when I was writing my brief, I said, someone get me that congressional record, because we read, and you just happen to repeat what I would say is a fallacy. Senator Smith from Virginia did not bring it up as a joke. In fact, he says, I'm very serious. Let's add sex. And they had a debate with the female senators as well, and other male senators. I'm sorry, congresspersons, congressmen and women. And it wasn't a joke. But for some reason—
I'm not saying it was a joke. I'm just saying that the legislative history itself is
sparse,
which is not to say that your position is not defensible. I'm not saying that at all. I'm just trying to get a sense of, how we got there and how we go from there to here.
On-call tells us—
On-call is supportive of your case. On-call, and Justice Scalia says that statutory prohibitions often go beyond the principal evil to cover reasonably comparable evils. And your position would be that sexual orientation discrimination would be that kind of comparable evil.
Yes, it would be covered because, and a lot of the Supreme Court cases tell us it's better to go general, go broad and protect, because that's Title VII is a protection statute to protect employees based on skill again.
And I guess you also have Price Waterhouse.
Yes, Your Honor.
Could you explain how Price Waterhouse helps you?
Pricewaterhouse was the woman who was too manly. She happened to be, I think she was heterosexual, actually, but she was too manly. And Pricewaterhouse, of course, says sexual stereotyping gets protection. And then this court, after Simonton, came up with, in Dawson versus Bumble v. Bumble, sexual stereotyping. Let's not blur the lines. Let's not bootstrap homosexuality to sexual stereotyping. Your Honor, of course the lines are blurred. How can you possibly say a heterosexual female like Pricewaterhouse, who's somewhat manly, aggressive, whatever, gets protection because she's heterosexual, but the same woman would not get protection if she was a lesbian? The lines do blur, so why carve them out? It blurs for a reason, because we're all men and women first and foremost. Matthew Christiansen is a man. He doesn't meet people and say, hello, my name is Matthew Christiansen, I'm a gay man. He didn't put that on his job application either. And we also don't have on our passports or our licenses male, female, gay, straight. We're men and women first and foremost, and the purpose is skills. We're here for skills in Title VII.
Counsel, is there an argument to be made that sexual orientation is in fact just a form of sexual stereotyping, and therefore it fits under the coverage of Title VII? Does Pricewaterhouse help you with that, or any of the other Supreme Court decisions?
Your Honor, the way I see this sexual stereotyping thing is really just social norms, social graces. That's actually, how I see it. I don't personally, in my mind, believe that we should have a sexual stereotyping. I still say that if...
I understand that's your thought, but the Supreme Court has said sexual stereotyping is covered under Title VII. So my question to you is there an argument to be made that sexual orientation is just a form of sexual stereotyping?
Sexual orientation, yes, Your Honor, I would say sexual orientation is a form of it, because they're saying even in Dawson that it's so blurred they can't segregate sexual stereotyping from the homosexuality. So why not take that group and keep it together and say, if sexual stereotyping, if you're heterosexual or a homosexual, you get... Sexual stereotyping, in my mind, Your Honor, I'm sorry, I can't reconcile that. It shouldn't exist. If you're sexual stereotype because you're a heterosexual female acting male, you get the protection. But if you're a homosexual female, you don't get the protection. It needs to... it's blurred. Sexual...
And it's your position, just making sure I understand. So you could prevail if we were to re-examine our precedent in Simonton and Dawson. This panel may or may not have the authority to do that on its own, but that's one way. But even apart from that, you're continuing to argue that under our old precedent, there was enough here, there were enough allegations of sexual stereotyping that the district court erred in dismissing it under that precedent, in dismissing the claim under that precedent.
I'm sorry.
Am I being clear?
The district court in my case erred, yes.
Yeah. I mean, because I read the complaint, there were allegations of that the plaintiff's, the supervisor was saying the plaintiff's exhibition of behavior, quote, was stereotypically inappropriate for men. The supervisor had acted against him on that basis. This Muscle Beach poster, there may be a reading of within our precedent that would afford your client some relief.
Yes, Your Honor.
Can I, though, also ask you about the statute of limitations in this case? The incidents in the complaint are alleged to have occurred between 2011 and 2013, and then there is the Facebook post in September 2014. you're arguing that that's sufficient to bring this within the continuing violation theory. Could you help me out with that a little bit?
Sure, Your Honor. The Facebook post, well, the four corners of the complaint, he discovered it in 2014. We immediately wrote them letters and said, enough already. You know, it's bad enough what he was going through and being, you know, called all these names and accused of having AIDS and this and that. But now you have him up in, you know, with his legs in the air in that bikini shot on the poster. Take it down. They wouldn't take it down. They wouldn't take it down, which was more of their kind of, it's in your face, there you go, we're going to keep making fun of you. It took us to write to the EEOC, which was well within 300 days. So September, it was discovered. If we were